We're back and now let's settle for the details of the stories we have for you this afternoon. My name is Elton Bobo. Your comments are welcome via our social media handles on X Spaces, on YouTube, on Facebook, and of course on myjoyonline.com. Now, Parliament this morning was thrown into chaos once more today as Speaker Alban Baben adjourned the House indefinitely. NDC MPs turned up early and sat on the majority side for the urgent recall of the House, called by MPs to consider some 17 very important government business. But the MPP MPs did not show up, forcing the Speaker to adjourn the House indefinitely, the second time in just 2 weeks. And this is his justification.
MPP members of Parliament, and it was signed on their behalf by the second Deputy Majority Whip, Honorable Alex Tete Joe Dubois. In fact, both requests were signed by him. Honorable members, I had, under the dictates of the provisions of the Constitution, to issue the summons for you to be here today. And I duly complied with the constitutional provision and got the administration to get the summons published to the notice of all of you. Unfortunately, the signatories who made the request have not shown up, and therefore matters that they wanted us to handle, which are admitted for the consideration of the Business Committee, are not on the order paper, and in fact there's no order paper for today because the Business Committee could not meet due to the absence of the people who requested for the recall. And as you can see, one side of the House is completely empty. In view of this, we have, as usual, got a quorum to sit, but we have no business before us to transact, because the Business Committee, as you know, they prepare a report, and this report is adopted by the House as business agreed by the House to transact during the course of the week. In the absence of that, there is no other authority that can put business before you which you have not adopted to transact. In view of the failure of the Business Committee to sit, as a result of the refusal of those who requested for the recall to show up, we are compelled to once again adjourn the sitting of the House. Knowing the challenges we are facing, it is not advisable to be adjourning from day to day. And so I'll proceed once more to adjourn the meeting indefinitely.
So what does this hold for Parliament and, of course, government business going forward? We'll have an analysis for you shortly. But now, Koko Sante was in Parliament all throughout this drama, and he joins me in studio with some perspective to the matter before the House. So, Koko, I mean, in the morning, yes, you went there. We saw on TV it was only the NDC side, the minority side, that came in.
Yes.
Walk us through events from the morning up until when the Speaker came in.
Well, Elton, just like the last time Parliament sat, the NDC MPs did arrive in Parliament very early. In fact, as early as 6 o'clock a.m., some of them were already there. And our understanding was that the NPP MPs, the majority MPs, had actually been there earlier. And this is information that the majority, that Alexander Fenyo-Markin, is giving out during the press conference, that they actually went in there to audit the space to make sure that their name tags were where they should be. But they didn't show up between then and when the House adjourned. So at 8 a.m., the doors were opened, and the NDC MPs who were there, numbering about 40 at the time, just started walking in. And they walked in right to the majority side and took their seats. And with time, up until about 9:30, the numbers kept increasing. At the time there was in the adjournment, there were almost 100 of them who were already in the House seated, right? So around 9:30, 9:45, the convoy of the Speaker then came in from his office in Parliament to the conference center. He did go in there, and he invited both leaders to come for conclave meeting and a discussion. At that time, still, the NPP MPs and their leadership were nowhere near the Chamber of Parliament.
And at some point, I saw you interact with the former Western Housing Minister, Samuel Atachia.
Yes. And in fact, that was all before the Speaker of Parliament will come in. So when the Speaker of Parliament came in, sat in his office, did some conclave meetings, the NPP MPs had still not showed. So whilst we were waiting for the Speaker of Parliament to gavel in and actually get proceedings underway, Samuel Atachia comes in. Obviously, he was coming in expecting that he was coming to take his seat on the majority side. He looked at it, and the NDC MPs had taken their side. And then he looks over the other place. There are none of his colleagues around. So he was a bit startled.
So what? He was not aware.
He was absolutely not aware. In fact,
but he thought his colleagues were already
in the chamber. And so he actually come out and try and speak to journalists and say, there will be some caucus meetings and they're going to have that. But ultimately, he was going to inform them that the Speaker has come.
Okay.
So are we going to come, or what is this? What is the strategy? So he actually did leave, and no other NPP MP came again. So that is when the Speaker of Parliament did take his seat and just proceeded straight to do what he had to do, to say, like we've heard him say, that these are the NPP MPs who recalled Parliament. These are the guys who appended their signature to a recall, but they are nowhere to be found. And they have also not programmed the business for us to work. Although I've admitted the business they list in their request, they are not here. They adjourned the House, and the NDC MPs who are taking the majority side in their numbers just started walking out together with the Speaker. And then the House again, sitting and standing adjourned indefinitely.
So this was a meeting that was to consider 17 urgent government business, but lasted maximum 15 minutes.
Yes. Because
the MPP MPs did not show up.
Yes. The only thing the Speaker did today, apart from adjourning, was to say the prayers. There was absolutely nothing else the House could have done today. Ultimately, the expectation was that if the MPP MPs were there and it had been a proud business committee meeting,
exactly,
the business committee the business committee report would have been presented, and then we would have formed the basis for the work the House was coming to do either today and the days ahead. But that was not there, and there was, in fact, today they did not distribute other papers to MPs because no other paper had been created except the documentation that have been submitted to the Speaker.
And it appears to me that there was also no pre-sitting meeting between the Speaker and the leaders.
Yes, they did not do any pre-sitting meeting. The Speaker of Parliament just came in, went to his lobby, that is just behind where he sits in Parliament, and then he called for the leaders to come. And ultimately, at that time, on the floor, there was only the NDC MPs. They went in there briefly, they came back to take their chairs. The Speaker of Parliament himself walked in and then adjourned the House indefinitely.
And then we had reaction from both sides.
Yes, we first heard from Dr. Kassel Atofos, the NDC group leader, the minority leader. Right after he walked out of the chamber, he spoke to journalists. He says he believes that the NPP MPs have caused financial loss to the state and that he does not see that they are serious about prosecuting government business. For them to recall Parliament and fail to show up, he believes the Ghanaian people must chase them out during the 7th December election for causing financial loss to the state.
Right, so we'll bring you the reaction from the NDC leaders' comments after the adjournment of the House. Again, you spoke to Katie Hammond.
Yes, and Katie Hammond was furious. Katie Hammond, I don't know where he came from, but he was sweating when he came in at the time. Obviously, I don't know if he came in time, he would have stopped the Speaker from adjourning indefinitely, but he just came right at the door and he started lashing out at the Speaker, saying that the Speaker was simply acting in a way that was an affront to the ruling of the Supreme Court. He actually insisted that his side will cite the Speaker of Parliament for contempt. I was asking him, why haven't you showed up? Because if you showed up, then if you have these concerns, you can bring it up. He says, once the Speaker of Parliament had not asked the NDC MPs to go back to their minority side, then there was no way they were going to come, because in his words, first things first. And they expected that the Speaker of Parliament, right after he took his seat, would have walked back his declaration of those seats vacant by virtue of the ruling of the Supreme Court, and even the Speaker going back to the court to vacate that order, and the court refusing same. And so they expected that the Speaker of Parliament will come in there and act by announcing all this. They didn't do that, and that is why they didn't come up. And they believe the Speaker of Parliament is acting in a way that is in contempt of the court.
Propose legislation, but this is not
decision. The ruling that I made on the particular day has been overset, has been stayed by the Supreme Court, which interprets the Constitution, interprets what we do over here. Accordingly, the status quo ante should be reverted to. So we would know that we are going back to this. Why should the NDC guys rush to go and sit on the side of the NDC? What is that? No, but that is not the point. Where were they sitting? Where were the NDC people sitting? No, you are not listening to me. You are not listening to me. Let's get the facts right. Where were the NDC guys sitting? Is that where they're supposed to be sitting? But you see, we have a convention. We have a convention. It's not argument, nonsense. You guys are not listening. Supreme Court is speaking. It is not for us members of Parliament on the majority side to be arguing any point. This is a matter. This is foreclosed. It is completely foreclosed. Supreme Court is speaking. That is the end of the matter.
The Speaker of Parliament says, when it comes to seating arrangements, that is not his business. He says he should come and sit anywhere and do the business.
Listen, the orders of the Supreme Court were directed specifically to the Speaker. It was the Speaker. It wasn't the leadership. It wasn't the clerk. It wasn't the leadership which made that ruling or that decision. It was the Speaker of Parliament who unconstitutionally made a proclamation, whatever it is that he said the last time. The Supreme Court has told him that he was wrong. Restore matters to what they were before you did that.
Line of action for the MPP.
Well, we will cite him for contempt. We will cite the Speaker for contempt. Watch the space.
So when we spoke about contempt, I'm wondering the grounds upon which he is thinking of such a move.
Well, he says that by the Speaker acquiescing to the NDC MPs taking the majority side, he clearly is in the know that the court has said that those 4 seats that were declared vacant should be stayed, which ordinarily means that the NPP have 138, the NDC have 137. And that ordinarily also means that the right-hand side of the Speaker must be taken by the majority, and they are the majority. So by the Speaker allowing the NDC MPs to take that side, the Speaker is clearly breaching the orders of the Supreme Court.
Yesterday, the Speaker was clear at the news conference that, I mean, arrangements in the chamber,
it's not his business. Exactly. He says
it's the clerk's.
And in fact, this morning, our understanding is that the clerk had done that. The clerk had actually arranged the names in such a way that the MPP MPs were still in the majority. But because they had not showed up earlier to take their seats, the NDC MPs who were there in their numbers, who had already been insisting from yesterday that they were in the majority, actually went in there. In fact, in the Afenyo Marking press conference that we'll get to pretty shortly, whilst he was speaking, people like K.T. Amon and other MPs were asking him to say that they are going to cite the Speaker for contempt and that they should even make moves to impeach him. And K.T. Amon had come and he was standing very close to him. So he was very particular about the conduct of the Speaker. His clear disagreement, you hear him there in the sound, clearly frustrated by the Speaker's adjournment of the House indefinitely again. And he says that the Speaker of Parliament should be cited for contempt. Even after that, Alexander Afenyo Marking press conference, I speak to him again, where he continues to make the point that he expects that the Speaker should be cited for contempt. But ultimately, the leader of the MPP caucus himself, Alexander Afenyo, has been explaining. He says, they were in the offices, they were watching proceedings. They just could not come because the Speaker had allowed the NDC MPs to take their seats. And that is why they had to stay away. And they say that the NDC MPs are simply inviting chaos. And if they come there, they will also insist to take their rightful seats. And if they come and the NDC MPs say, we're not going to give it up, then it could lead to violent confrontations on the floor. They don't want the 8th Parliament to end the same way it started. He's making the same point he made the last time when they walked out of the chamber, that they are for peace and they are not going to do anything that would destabilize the Parliament of Ghana.
Let's listen to Afenyo Marking justify why they did not show up in the chamber.
One was expecting, Mr. Speaker, to direct the NDC to do the right thing. He refused. Subsequently, Mr. Speaker engaged the Council of State, or perhaps let me say the Council of State held meetings with Mr. Speaker. As a majority leader and leader of government business and leader of the House, I had the opportunity to also meet with them. The understanding I had from the meeting as a sequel to the meeting they had already held with Mr. Speaker was to the effect that Mr. Speaker will direct the NDC minority to sit at their right place, which is the left of Mr. Speaker. That was the understanding I had. I subsequently had a call from the Peace Council. The Peace Council informed me that they had engaged Mr. Speaker on the issue before Parliament, and Mr. Speaker had indeed indicated to the Peace Council that he had not ruled, neither has he proclaimed the NDC minority, and that should we resume or should Parliament reconvene, the NDC minority will go back to their seats. Several other prominent Ghanaians, who for some good reasons I would not want to mention their names, who had engaged Speaker on this matter, had also reached out to us, the majority caucus, and assured us that Mr. Speaker's engagement with them resulted in he admitting that indeed there was no such ruling, which ruling would now proclaim the NDC as a so-called new majority. Now, from the horse's own mouth, granted that all these prominent people misrepresented to us, the majority, yesterday, Mr. Speaker himself, in his press conference in the afternoon, enumerated a number of things. Among them, he said he had not made a ruling. He told the whole of the country that he had not made a ruling. So, if he claims that what he did was a formal communication in response to a statement from the minority leader, then why is he supervising chaos in the House? What Mr. Speaker did today amount to supervising chaos and bringing the image of democracy to disrepute. The NDC minority members were all over claiming that we, the majority, did not attend a so-called business committee meeting that they called. Who are they? When did we constitute a new committee in Parliament? I chaired the business committee of Parliament. And when the clerk to Parliament asked for the business committee meeting, I was very explicit that the subject matter of the recall, which was approved by Mr. Speaker, is a very matter for consideration. So there's no need to have another business committee. Business committees should decide on the business of the House. On this occasion, you have made an application, which application has been granted. And the items that were approved were the very things to be decided on. So I directed that the business...
So Alexander Afenyomarkin is the majority leader of Parliament. And Koku, so what is next? Are they going to have another recall?
Yes, they say that they are going to engage the Speaker in the next hours and in the next days. But if the Speaker does not budge, they are going to force another recall. And so, in fact, at the time I was leaving Parliament, I understand they are gathering signatures to put it on standby once the Speaker of Parliament does not acquiesce to their demand to reconvene the House. And then they will just proceed and give that. That will mean that in the next 14 days, the Parliament of Ghana would have to come and sit again. That will be barely 2 weeks to the 2024 election. And NDC and some of them are furious. They say that they need to go back to their constituencies and campaign. This saga, there's no any side else.
The four MPs, were they in Parliament today?
All four of them were not in the chamber of Parliament. In fact, the second Deputy Speaker, Andrew Amakosi, MP for Femina, his assistant was in the chamber, which indicated that he wanted to come. He was there up until the Speaker adjourned. And then later on, when Alexander Afenyomarkin addressed journalists, Cynthia Morrison was part of the the NDP MPs currently, who were part of that delegation who addressed the journalists. She was standing right behind the leader, Alexander Afenyomarkin, and they were there. The other two Suhum MP Kojo Asante was not in the House today, and then Peter Yakwachiaka wasn't also there.
Asante is our parliamentary correspondent. Thank you so much for coming. So, the way forward in all of this and the implication this will have on our democracy when we come back from this break. So you've been watching events in Parliament today and of course in previous days, and there appears not to be any end in sight as far as this matter is concerned. What is your own recommendation? Send us your comments via our social media handles on Facebook, on X Spaces, and of course on myjoyonline.com. But Sami Obeng is with the Parliamentary Network Africa, and he joins me. So Sami, you've been watching this. I mean, how will you describe that what we are seeing before our very eyes in this 8th Parliament?
It's unfortunate, avoidable, like I have kept saying. And I think now we are getting into the realm where the members of Parliament, the politicians in Parliament, are assuming that none of us outside of Parliament understands their rules, understands the processes that must be undertaken in having an emergency sitting such as this. And I think that is very unfortunate. And we need to get out of the sheer misbehavior, really, of our members of Parliament, because government business needs to be transacted, and it needs to be transacted quick. Now, let's start from what needs to be done on a normal emergency sitting day before the House or members of Parliament even take their seats. The standing orders of Parliament are clear, and I think that there are many examples of emergency sittings. I mean, you have covered Parliament for years. And on a typical emergency sitting day, the Business Committee of Parliament will sit very early in the morning and will determine the agenda of the day's sitting, from where the table office will now liaise with printing to ensure that the order paper of Parliament is out. The old standing orders of Parliament makes the majority leader the chairman of the Business Committee. But I'm sure that we are aware that the current standing orders of Parliament actually changed that arrangement, perhaps envisaging that we may have a situation like this. Order 216 of the standing orders of Parliament says that the Business Committee comprises the leader of government business as chairperson.
So the leader of government business could be in the minority side or the majority side?
No, the leader of government business is leader of government business. It's that one, and the leader of government business is defined by the standing orders. It is the leader of the party that forms the government.
But the leader of government business in Parliament is who leads the caucus.
Exactly, who leads the caucus that forms the government.
Right.
That's why he's leader of government business. So it's deliberate that the standing orders did not say the majority leader, right? Which was the situation in the past, because the new standing orders were created with the understanding that we may get to that point where we may have the majority in Parliament not being the government side. So Honorable Afenyo-Markin is leader of government business. And in fact, it's the role that Honorable Keslaf Tuforsin cannot take up.
Right.
We heard Honorable Afenyo-Markin on TV in the presser say that instead of calling a business committee meeting, he instructs the administrators of Parliament and say, we did the petition. The petition has the list of items which are supposed to be discussed. So that should carry without a business committee meeting. That's completely not what Parliament does. And I think that it's important that all of them, members on either sides of the aisle, get to recognize that their standing orders are public documents. Parliamentary practice and procedures are known by at least the Ghanaians who care to know, and there are ways in which this needs to be done. So that was the first issue. And I think that it was quite an affront for the Speaker to sit in the chair and indicate that there was no order paper because Business Committee did not sit. That preceded the sitting arrangement in Parliament. And I think that as members of Parliament, they had brought this upon themselves. Right Honorable Speaker adjourned the House sine die so that they can sit and, like he stated in his press conference yesterday, be able to come up with matured compromises and negotiations
on the way forward
to ensure the way forward. 2 weeks down the line, they've done none of that. They show up today, waste our time.
And clearly, even today, there was no sign of a meeting prior to the speaker entering the chamber.
It's completely not what happens in Parliament. Those of us who cover Parliament, who work with the institution of Parliament know. And so these politicians, unfortunately, at this point, must be called out. They must be told that they are taking us for granted, and that must not be the case.
So somebody decided to secure the signatures of his colleagues, trigger the relevant provision in the standing order, got the speaker to call MPs into the chamber to consider what we are being told are supposed to be 17 urgent government business. The person who triggered the motion did not even show up on the floor to push it. So clearly, I'm beginning to wonder whether there was even the need for an urgent call, also push the speaker to recall Parliament at all costs, even though there was no business to be considered.
It remains within the rights of the members of Parliament who signed that particular petition by constitutional provision to recall the House, right? And of course, the Speaker is mandated once that has been triggered to do that. But you see, the last recall, emergency recall we had, ended in a disaster similar to this. What it means is that our leaders in Parliament are perhaps not learning. You know, we need to get to that particular stage where people must be held accountable for their actions and inactions. And these are some of the clear instances. Unfortunately, some of these things when Parliament does derails all the great things that this 8th Parliament has been able to achieve. We are 2 months to the end of this 8th Parliament. And these recent issues are perhaps leading us to the point where it may seem like this 8th Parliament has done absolutely nothing. Right. But they've done some amazing stuff. Unfortunately, they are really wanting to end this 8th Parliament as it started. And that will be really, really, really...
because you've had times to peruse the new standing orders, I will come to ask you about your understanding of what the Speaker said yesterday, that in the matter relating to the states of the 4 MPs, he only communicated a message to members of Parliament, and he did not offer a ruling on the matter when members debated the statement that was presented to the floor by the minority leader. But I'm just going to pick your mind on this matter. Usually we are in November, and at this time Parliament should be considering, or government should be preparing to read the budget to the floor for the necessary consideration to be done. The Member of Parliament, Kennedy Osenyako, says Parliament is to pass a 3-month expenditure on account, which basically is for salaries and other essential and statutory payments. From the look of things and the posturing taken by the NDC caucus in Parliament, I'm afraid this appropriation will suffer a consensus approval. The total effect is that public workers, including security agencies, are unlikely to get paid for the months ahead. And this is something we're all looking forward to. It didn't happen. Is there a possibility that this can still happen?
Fortunately, when the House adjourns sine die, it means that the House can come back tomorrow.
Yes.
Because adjourning sine die is without a definite date of resumption.
Absolutely.
It can be next week. So the ball really is in their courts as members of Parliament to do the things that must not be with the cameras present, the backroom conversations, which are an integral part of parliamentary work. It is not for nothing that in every parliament the world over, beyond the chamber, there are the lobbies. There are those rooms where they go to negotiate, they go to have conversations. There is the Speaker's lobby where you go to have discussions away from the media. There are portions and sections in every parliamentary chamber where the media is not even allowed access, just so that conversations can go on and we can be. So I personally think that members of Parliament at this point do not need to be showing what I keep calling needless show of bravado when the cameras are on them. They should at this point be in the rooms having conversations, even with the executive branch coming down to the legislative enclave to have the conversations on the ways forward around this. Yes, the Supreme Court is going to make its ruling on the interpretation of Article 97(1) G and H. And for me, I look forward to that coming quick so that it settles the constitutional interpretation aspect of things. But beyond that, there is work that needs to be done in Parliament. And you see, you cited the budget for the purpose of our listeners.
Expenditure on account for the first quarter of 2025.
Yes, which is the technical way of saying it. I usually like us to also allow our viewers to understand it by what they know best. The budget for the first 3 months of next year, which certainly must be approved of, so that the new government will have at least a 3 months budget before
they present their own.
They present their own. Now, this is where we find ourselves in. Whoever gets to win the elections on January 7th, by 2-3 days, maximum 1 week, we probably will know who is our new president and who is forming majority. Whichever way the pendulum swings, we may still have a challenge with people using parliament as a way to stifle the efforts of the other side if they do not resolve these matters now. So, hypothetical situation, if the current government, the NPP wins the elections, we may still have, some of these situations. If the NDC wins the elections, the NPP may also go back and say, well, we're also not coming to parliament. So they have no choice than for both of them to ensure that soldiers, police people, teachers, public sector workers are able to deal with the issues that they are able to have their salaries for the first 3 months, and government business does not come to a halt. And this responsibility is on both of them equally, majority side and minority side.
Right.
I think that they need to...
The Attorney General has a position on what is playing out in Parliament. We've got that exclusive interview coming up pretty shortly. But what is your understanding of the Speaker's position on the 4 MPs? Yesterday, he told the whole world that he did not rule on the matter. He only gave them some kind of a notice or a statement to that effect. The NDC appears to be holding on to the earlier quote-unquote ruling of the Speaker to now arrogate upon themselves the majority status. What is your understanding of it, and how must this resolve as we end up?
Respectfully, I think that yesterday the Speaker sought to backtrack on what he did in the chamber through a press conference. I mean, business in the chamber is a thing of the records. In that particular declaration, at least we heard the Speaker. He described the 4 MPs and then described their new nomenclature, so to speak. Independent parliamentary candidate as blah, 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 essentially indicating that their seats in Parliament have been declared vacant. Yes, that could be said to have been a communication by the Speaker to the House, but that communication has caused what we currently find ourselves in, and we need to, find a way around it. I think that the Supreme Court's interpretation of 97(1) G&H, which I understand may probably be on the 11th of November, if that is correct, may settle this matter for us. And of course, the Supreme Court knows the stakes and how high they are, and they probably also know that these decisions will have future implications and will do the needful. I am expecting that will be done from that particular level.
Sami, thank you so much for coming through this afternoon for us. Of course, this matter will not end anytime soon, as we await the final determination of the matter before the Supreme Court. We'll take a short, but when we return, the Attorney General has his own perspective on this matter. Stay put. Welcome back. This is the pulse here on Joy News. Now, the Attorney General and Minister for Justice, Godfrey Ebadame, has been responding to these and many more issues regarding what is happening in Parliament, the matter before the Supreme Court, the expectation he has on the Speaker of Parliament. In our exclusive interview with Super Morning show host Kojo Jansen. And that's how I'll take a break here on the pulse. My name is Elton Brobe. Kojo Jansen is up next as we speak to the AG on a variety of issues, including the matter before the Supreme Court and Parliament.
Well, thank you very much for having us in your rather lovely new office. Lots of things have been happening that fall under your ambit and purview. I think it's a good opportunity to catch up with you on some of them. Right. But first of all, today is the day on which Donald Trump returns to the White House. What are your thoughts on how the American election have gone?
Well, just to make a brief comment on what you said, lovely office. I think this is the very first time you're coming in officially to conduct an interview. Yes, the office was commissioned on 10 June 2024, to the glory of God. Indeed, it had been a construction for about 23 years. The current president started it when he was Attorney General in 2001. And by the time I was in office as Attorney General in 2021, was only 36% complete. But by dint of the commitment of resources by the president, and of course, the sharing of the vision that I had for this office, we were able to complete it. And I think that is really a symbol of the president's commitment to the rule of law, advancement of issues relating to governance and what have you. Well, Donald Trump is coming back to the White House. I think that, well, it's for the people of America to decide, which they did. It's their sovereign right. It's definitely not the right of any Ghanaian at all to make a decision on how America votes or who they decide to be their leader. I've seen some people trying to make some noises about this. I do not think that the situation in Ghana definitely is like that of America. And indeed, if there are any parallels to be drawn, I think that parallel should be that in terms of philosophy and all, it is a new patriotic party which has that similarity of philosophy with the Republican Party. Of course, the symbol is the elephant. I don't think the symbol of the Republican Party is the umbrella. Some people are seeking to now lay claim to. And I think that if indeed the history of Ghana and America is anything to go by, except when the trend was broken in 2020. Anytime the Republican Party had won in America, the MPP had also won in Ghana. It was only in 2020 that trend was broken. So clearly the breaking of that trend even suggests that there's nothing so much to be made out of the victory by a particular party in America.
But is it really an insignificant thing that we have seen a former president regain the White House, and we've seen a vice president seeking to step up fail to do so? Is it not significant?
I mean, again, well, I would say that America has a very long history, and indeed, going by the long history of America, that has never, I think for once, or only once or so, that that was successful, a vice president coming in and all that. Clearly, that is not Ghana's history. I mean, we have had some vice presidents, so of course, we will say that Mills' own was after a broken period, and then he came later on. Of course, John Mahama himself was vice president up to 2012, a part of 2012, and then 3 months or so before the election, by the unfortunate circumstances that occurred, he became president briefly, but he was able to galvanize with the support, if you may call it, that he had when he was vice president, and then that translated into his ascension to power as a president in 2013, January 2013. So it is not clearly the same. The situations cannot be the same at all. And again, I would say that the factors that occasioned the victory of Donald Trump clearly are different. Abortion, rights, and the right of a woman to her body, matters relating to even war and the handling of war situations by America and all that. I don't think Ghana has that that command on the global scene as we're worried about Ghana's approach or attitude in war situations. So it's definitely not a factor.
The economy, however, is something we have in common in terms of issues.
Yes. The economy is something we have in, and of course, development, the general development of the nation is something that we have in common. And of course, even this office clearly is a symbol to the progress of the party, of the advancement of the Ghanaians' life by the MPP. As I said, before this facility was completed, and by the time I came in 2021, the building had been started about 22 years at that time before, was only 36% complete. Within about 2-3 years, we had got it done. So that tells you that the MPP really knows how to get things done, and indeed the MPP's commitment to advancing the life of any group of people at all. One can allude to the advancement in, of course, in healthcare that we witnessed in President Kufuor's time, and of course when we came as well, the payment of nursing trainees, trainee nurses allowances and all that. The free SHS, which of course you cannot really take away from the president. That is a real improvement in the life of the Ghanaian. The road construction, numerous roads being constructed over the country and all. And clearly, these are things that you cannot deny. And so in terms of practical development of the life of the Ghanaian, I do not think the NDC can say that when it comes to that, they are much better than the MPP. Definitely not. They cannot be better at all. In the area of good governance, I sit here, this office, I see numerous transactions that result in judgment debt and all that. And these are matters that were inherited. All the arbitration cases that we're conducting in this office, the numerous claims that we've successfully fought off, which of course I will be justified in thumping the chest of the office about, were matters generated in the NDC time. The various contracts that were signed without PPA approval, which resulted in litigation the various contracts that were badly managed, which resulted in huge billions of claims, dollars and cedis against the government of Ghana, which were it not for the diligent, if I may say, diligent hand of the Office of Attorney General in the NPP time, would have collapsed the Ghanaian economy. I mean, these are matters that the Ghanaian people ought to know about. In terms of good governance, can again refer to the dubious judgment debts that were very much a frequency in the NDC time. The Wayo Maize, the Asofotons, you name it. And there are more that I've seen in this office since I came. So indeed, I would think that in terms of the election of a leader's credibility, in terms of managing affairs of the state, in a way as to ensure accountability is very key. The leader's credibility in terms of managing the public purse in order not to occasion unnecessary losses to the state is very much fundamental, very, very key. And these are matters that have to be considered. I did not see that being a factor in America, or just the issues of economy. And as I said, issues of road construction, issues of free SHAs and all that are not factors in America. So our economy has different dynamics, and we have to appreciate it.
You made this point about the potential cost of arbitration, which through the work of your office has been avoided, and how it could have been a threat to the very existence of our economy if you hadn't won in these instances. There are those who point to this and suggest that we should then pay a bit more attention to the contracts that have been either signed or run under your government, and of course while you've been Attorney General, which could potentially put the next government, whoever wins, into serious debt. For example, in the energy sector, where we've currently racked up debts up to about $2 billion, simply because of how we have managed, or in some people's view, mismanaged the contracts we have with independent power producers. This has happened while you've been Attorney General. Has it been against your advice?
Well, I don't know how the debts were occasioned simply on account of the execution of some contract. I think the debts, of course, were occasioned principally by perhaps the failure to pay certain debts that accrue. So that's different from a situation where the government has signed a contract imposing burden on the people. And indeed, I think there was a complaint made in the early stages of the MPP administration, 2017, 2018, 2019, that there was excess supply, excess capacity generation and all that. And that is an account of the execution of many unnecessary power purchase agreements. That's a matter for the technical people at the Ministry of Energy to really look into and determine. But there was such a complaint. I believe that the media actually gave a lot of publicity to it and all that. So if indeed there's the execution of so many unnecessary agreements in the NDC time and all that, clearly it imposes liability. And I remember that one such agreement, which was terminated, was what led to the famous 170 or 160 million judgment debt in the name of a GPGC, the traffic bureau one. That was it. That was just before I assumed office as Attorney General. And so clearly, I mean, as I say, that when it comes to the execution of contracts and all that, we must pay particular attention to it. And indeed, when there's a complaint that a government is unnecessarily signing contracts, it is one that cannot be taken for granted. We must look into it seriously. I thought that there was a legitimate basis for a scrutiny of all those complaints by the MPP during that time. Of course, some people played political football with it and tried to justify the execution of those agreements and all. And we have seen the consequence of it.
We must, however, point out that a lot of these contracts that your party complained about, that they were unnecessarily signed by the previous government, were renewed when the time came. So it would appear that you...
No, I'm not aware of any such. I mean, as I said, there's also what we call division of labor in government. It's a point that must be recognized. There's division of labor in government. The Attorney General's remit in the Constitution, of course, is to be principal legal advisor to the government on all issues. But the Attorney General only acts when certain matters are being brought to attention. And of course, with all respect, I'm a lawyer, and on behalf of the state, speaking on such an important issue, I would not speculate at all. You have not referred to a particular contract that you see that this contract was signed after referral to that Attorney General.
I'm talking about the independent power producer contract.
I don't know of any such renegotiation that was done pursuant to the advice of the Attorney General. So really, in all honesty, I'm unable to speak to it. Because I think it will be quite helpful if there is a particular instance of the execution of such a contract alluded to and pointed out. Many a time, when agreements come which are unnecessary and all that, we advise against it. So I'm not in a position to actually speak
is this to say that you have not been, your advice has not been sought on any of the...
I'm saying that you have not alluded to a particular advice. You're just making general statements, with all respect. And those general statements, I'm not able to respond to them because I'm not, with all respect, speaking like a communicator on radio who is at liberty to make comments on matters and perhaps be excused because the person has no evidence. This is the Attorney General of Ghana. And I think it will be very fair for me to say that if I have to comment on an issue, it must be in relation to a specific issue. Then you must clearly point out which specific contract and that kind of thing. And I'm saying that you have not really done that, and I'm unable to therefore respond.
Okay, we will come back to this if time permits. But let's recently, when you spoke at the inauguration of the first ever conference for public sector lawyers, you made this point about arbitration, and you enumerated a number of cases which you've had to defend the government of Ghana on. And as a result of your success, we have avoided some trillions of dollars worth of debt.
Right.
The suggestion here is that, well, I mean, you're Attorney General, that's your job. You know, you've done your job. We ought not to be saddled with debts if we have a competent Attorney General who can protect us from it. Surely that's where it ends, is it not?
Yes, that's where it ends. And what was not really an attempt to lament or perhaps draw attention to myself for the success and all that. It was actually an attempt to draw attention to the potential pitfalls the nation will run into in the event of a default on some of the most important matters that ought to engage our attention. And the conference, of course, was the first of its kind, organized by myself, had never been done by this office. I found it very necessary to organize such a conference because, drawing from experiences that we had had the past 3 years since I've been Attorney General and conducting arbitration cases, there was actually a lot of danger that the nation was faced with, principally as a result of the failure of public institutions to cooperate. You go to arbitration hearings and you see that documents that the government of Ghana ought to be the one to have custody of and be the one to even know the content and all that, the government does not have a copy. And that these are in the possession of the adversary, the Western people, the white people and all that. And that is because of the diligence and meticulousness of the way they do their things. So investors come to the country right from beginning. They have record of everything, every step, every decision, or every action taken. Every email, they have it. You see the track of email that they can produce from 2011 when the transaction started up to about 2018 or about 2016 when the transaction was terminated. And the government of Ghana does not seem to either recall the necessary facts or maybe did not have a copy. So I feel that, indeed, as I indicated, there's division of labor in government. Be that as it may, the Attorney General is the principal legal advisor for the entire government. And that function cuts across every ministry, every department or agency. So within the scope of the functions of the Attorney General under Article 88, the Attorney General must be able to coordinate effectively with the legal department of other institutions of state. it's not only the ministries, departments, and agencies who solicit the help of their tenderer. The government is also constituted by other state-owned institutions and other state institutions. So, for instance, there could be a debt or a transaction within the remit of GNPC. GNPC, technically, is independent, has its own mind, has a board, has its own legal department and whatever. But whenever there is a claim against GNPC, the government of Ghana will be the one cited on arbitration. Even if the government of Ghana is not cited, the investor will not recognize a restriction as to the assets of the government of Ghana to fall on. It is always any asset the government owns. And for that matter, it is still the tenderer who will be responsible for the defense of sin. So I thought that it was very important that all lawyers in the public sector have to meet in order to coordinate effectively and all that. And apart from that, come abreast of the various or the relevant matters pertaining now. Because I think a major dispute resolution mechanism now is arbitration. And that, for me, really holds a lot of dangers for African nations. I spoke about it at the International Association of International Bar Association in Mexico earlier in the year. And that is because there's a lot of prejudice the African faces in arbitration. African countries really have a lot of prejudice because there's that track record of inefficiency of the African, track record of poor record keeping and that kind of thing. So clearly, most of the times, any objections raised and all that are disregarded. And I think that in order to avoid the occurrence of such judgment debts and potential collapses of the nation's economy, there ought to be a better strengthening of the framework within which public sector lawyers work. That's why I held that meeting. And the point I made about arbitration indeed having the potential to collapse the nation's economy is real. Because the recent ENI arbitration, were not for the dismissal of all the financial claims of ENI, we could have been saddled with a debt of at least 915 million USD, 950 million US dollars. The government of Ghana is actually looking for some funds, I think lower than even $600 million, pursuant to this domestic debt exchange program. And if the government was to have suffered a debt of $950 million, you can imagine the consequence. And that $950 million was actually even after a challenge by the government in the course of proceedings to the claim by ENI. The initial claim by ENI was, yes, the initial claim by ENI was $7 billion. And pursuant to the claim that we made, that claim was revised to $915 million USD. And that was also dismissed in its entirety. Apart from that, there's this cautious mining arbitration. Arbitration also arising out of an agreement executed by the Mahama administration on 28 December 2016. An agreement was signed by them just after their lost election and all that. And that agreement has led to the government being confronted with an arbitration claim. That is about 300 million. There's also this Eland Investment Limited, the transaction of which also occurred around 2011 and whatever, or maybe even much earlier, about 2009 or again also for about 320 million USD. And there are other claims. I can readily speak about this GCNet claim against the government of Ghana. GCNet, of course, was the company in charge of the operation of the port system, collection of revenue at the port of our nation. And that was a contract that was signed without PPA approval. That is very, very serious for the government to entrust the running of its port services, the collection of revenue, to a company, select a company, and for that company to run the service for over 10 years without any approval from the Port Procurement Authority. It's very, very serious. The original agreement was signed somewhere around 2000. There was no requirement of PPA approval.
There was no PPA law
at the time? Yes, PPA law at the time. It was for a 10-year term. When it was signed in 2000, it came into effect in 2002. By 2012, the agreement had lapsed. The Mahama administration, by just the stroke of a pen, by a simple letter, as they said it, decided to renew the agreement for 1 year, lapsing in 2013. Then by another agreement that they signed from 2013, they, again without PPA approval, gave a further 5 years, further 5-year period to GCNet to run our port management system, port revenue management system, for 5 years. 2013, when was it supposed to lapse if it had been given 5 years?
That would be
2018.
2018.
2018. Before the agreement would lapse in 2018, in 2016, October 2016, just 2 months before the elections, the Mahama administration again extended the term of GCNet by a further 5 years, requiring that it will lapse in 2023. So the agreement, the extension that had been made in 2013, which was supposed to last until 2018, by 2016 October, they had extended that term further by
even
5
though
years.
It hadn't yet lapsed.
So giving the company sole control of our port revenue generation system from 2012 up to 2023 without any PPA approval whatsoever. This clearly was unlawful. So the Finance Ministry or the Trade Ministry in 2019 terminated that agreement. The company then decided to sue the government, pursue arbitration proceedings against the government of Ghana, claiming well over 4 billion Ghana cedis. And that's the matter that was handled solely by my office, the office led by me. We argued it in April this year, and we're expecting the ruling anytime soon. So these are circumstances that I think that really called for a proper collaboration between all lawyers and public service in order to curb all these incidents and occurrences.
Even one of these cases could have resulted in an impact on the economy.
Severe impact on the economy. But I understand, the last year or last 2 years when the IMF was engaged and all that, I think we were looking for an initial amount of about 300 million USD. In total over, I think, about $600 million or so as staff for correction. But if any of these claims, $3 million here, $320 million there, 4 billion Ghana cedis, which is about $250 million, as well as $950 million has succeeded, the whole nation would have collapsed. So there's a need for the nation to take a very critical look at contracting and contract management. The processes of entering into a contract and the processes of ensuring the management or supervision of the execution of such contracts. And I think it's also a matter that the nation also to take account of when it comes to election of its leaders. Do not need, with all respect, or maybe biased, but do not need a person who would act with such reckless abandon.
Well, obviously, to take your own advice, coming into an election, I suppose we should also be looking at how this government has managed.
I think so. A fair deal.
Of this nature.
Fair deal. Fair deal.
Let's take a break. When we come back, we'll explore issues of Galamsey. They have also been quite topical, and a lot of it falls under the remit of this office. Stay with us. Welcome back. We're spending time with the Attorney General in his brand new office and picking his brain on lots of national issues that certainly pass across his desk. Before the break, I mentioned that we should spend some time on Galamsey. It's become the big national issue. All Ghanaians seem to have a voice on it. TUC threatened a strike not so long ago, and as a result, government sat with them and came to some agreements. Among those agreements were that, first of all, there would be the constitution of some special courts to fast-track the prosecution of those found to be engaged in illegal mining. Then, of course, there was the issue of the repealing of LI 2462, the one that permitted mining in forest reserves. Give us some updates on these two.
Well, I think it's important to recognize that Galamsey is actually a very serious matter. It is one that really affects the environment in which we all live, and therefore is really non-political. There cannot be a political stance taken on Galamsey. Whether the environment is good or bad, it affects all of us. And indeed, in recognition of the seriousness of Galamsey as an issue, I had already been talking about it, taking steps long before even the TUC and organized labor also started taking very critical or serious interest in the whole issue. So, in line with that, special courts had already been set up. I mean, the setup of a special court was not occasioned by the action of TUC at all, organized labor. The former Chief Justice, Enieboa, had actually set up some courts, and this current Chief Justice has also increased the number of special courts.
How many do we have at the moment?
That is why there was actually a problem as the numbers. Because the original one, I think, were just about 3 or so, but there has since then been quite a number, an increase in it by the current Chief Justice. So, and also every High Court has jurisdiction to deal with Galamsey cases. So for me, the solution to dealing with Galamsey is not setting up special court. The solution to dealing with Galamsey is expedition in the processes for prosecution of the illegal mining offenses. And I think about 3 years ago, I did a publication, and Joy FM spoke to me about it, and all, in which I lamented the slow pace of justice delivery when it came to Galamsey cases. But we cannot afford to treat all cases as the same. Galamsey is something that affects the integrity of the environment, and also even has implications for corruption, the fight against corruption, and what have you. So it's very important that we deal with it in a way as to show the total rejection of the practice by the entire citizenry. So I thought that the practice whereby the court will deal with cases bordering on illegal mining as business as usual was unwarranted, also was very much unjustified, and there had to be greater attention paid to it. But somehow, in my view, there has not been such attention. And we go to court all the time. We lament the adjournments that are granted by the judges and all. Aisha 1 is actually one particular case in which the High Court dealt with it expeditiously. And I think the High Court judge, Justice Lydia Osema, has recommended in that regard. I must also commend the Circuit Court Judge Atakwa also for the fast pace at which she concludes illegal mining cases and all. Indeed, most of the convictions that we obtain from the Western region are from that particular court. Circuit Court, I've forgotten about whether it's A or B in Takwa. And so when I made the so when I complained about the slow pace of justice delivery, I was expecting the judiciary to respond, perhaps. But I can see the same trend occurring. So today I got an update on Galamsey cases. Well, I've called for it almost every 2-3 days. I get an update of all Galamsey cases around the country. I asked the DPP to get all what has happened, and I follow. One case adjourned to 9th November, another adjourned to 12th November, another adjourned to 27th November. Some even adjourned to 4th December. Clearly, I mean, the face of this national agency, I think that it's very much unjustified for judges to grant adjournment as long as 2 or 3 or even 4 weeks for Galamsey offences.
The Chief Justice, though, suggests that the delay is from your office.
I mean, you know, my sir, I mean, definitely lead on the bar and all. Even before I got into public office, hardly will you see me quibbling with decisions or statements by judges and all that. But I think that the CJ, of course, I know has high regard for expedition when it comes to conduct of cases. But I think she has to really speak to some of the judges and all, and indicate to them to pay more attention to the handling of cases. I intend to convene a meeting with the CJ specifically about these Galamsey cases when she arrives in the country. I think she's not in the country now. We had already had a meeting scheduled between the Attorney General, Organized Labor, and the Chief Justice. Unfortunately, there was, if I may describe it as a mishap in the date. Organized Labor got the date wrong. They thought it was the following day, and I was ready for the meeting. CJ2 was ready for the meeting, but Organized Labor thought it was the following day, and that led to the meeting not taking place. I'll try and organize such a meeting again next week, and we're at a round table deal with the issues affecting Galamsey. Because something that the CJ herself also recognizes affects all, and that there must be greater attention and expedition brought to bear on it. Of course, the government took the urgent step of ensuring the repeal or revocation of the legislation on mining in forest reserves, LI 2462, also if I've gotten the number right.
2462.
Yeah, 2462. No. So I got it, the instrument drafted to revoke the earlier instrument, was duly signed by the Minister for Environment, whose remit fell within that specific subject matter, and was duly laid in Parliament on 12th October. So in my view, the failure of Parliament to sit now is militating against the fight against Galamsey. The failure of Parliament to sit now is militating against the fight against Galamsey, because under Article 11, Clause 7 of the Constitution, any other rule or regulation enacted pursuant to a power conferred on a person under the Constitution or any law shall come into force only A, when it is laid before Parliament, B, when it is gazetted on the date laid before Parliament, C, after the expiry of 21 sitting days of Parliament, unless Parliament announces it by a prescribed majority. I think it's about 2/3 or 3/4 of Parliament. So clearly, in order for LI 2462 to be revoked, it must be laid in Parliament for 21 sitting days. And when it was laid on 11th or 12th October 2024, after 21 sitting days, it would have been revoked. Parliament is not sitting, and so that instrument cannot be revoked. So a very important demand of organized labor is being frustrated by the Parliament of Ghana. That's why I think that the failure of Parliament to sit now and all the happenings in Parliament are very much unfortunate and has very far-reaching implications. It has an impact on the fight against Galamsey. And I'm surprised that organized labor is not bringing that kind of pressure to bear on Parliament. Perhaps their attention has not been adverted to the legal problem being created by Parliament.
When it comes to the fight against Galamsey, your conviction record is impressive. But the criticism always comes back that those who have been convicted are the small fry. Apart from perhaps Aisha Huang, who I think the public recognized to have been high up in the chain of illegal mining, every other Ghanaian who has been convicted appears to be pulled out of a pit and convicted under our laws. People keep pointing to the financiers, the ones who have been identified through work of journalists like Erastus Asari Donko to have been conducting illegal mining activity, like Akunta mining. We heard that the Forestry Commission was engaging in some investigation. They say they've completed their work. They say they've passed on the information to the police. We still see no prosecution of Akunta mining or any other companies that have been identified to be mining illegally. Why has your office not been proactive in this sense?
So I think that, well, you indicate that the conviction rate has been quite impressive, but I'm not impressed. I'm not satisfied. I'm not satisfied with the conviction rate. Yes, of course, there's a lot of conviction, and every year we report on same and all that. And I indicated at the Association of Judges and Magistrates Conference that the conviction comes, but the conviction comes in trickles. It comes in trickles. I'm not satisfied with the trickling of convictions. I would appreciate a lot of convictions every month. And that's where I say that there's a lot of work to be done by the court as well. And we can only get convictions when the court expeditiously deal with matter and conclude same. And that can be done. Now, Aisha Huang's conviction for me, we cannot belittle, because it was something that people pointed to as a demonstration of a failure to prosecute and all that. And indeed, the fact of Aisha Huang, we must admit, occurred in the John Mahama administration again. All the facts based on which she was convicted occurred between 2014 and 2016. She was never prosecuted by John Mahama's administration. There was not even any credible complaint that the Ghana Police Service investigated in the John Mahama time. It took my predecessor, Madame Gloria Kufu, working together with the CID to build a docket. And indeed, there was prosecution. That prosecution was discontinued. And she was, as you remember, repatriated and all. And then she sneaked into the country. Then I decided that she must still be tried again for her past crimes. And that prosecution was pursued with earnest, was undertaken with a lot of vigor. Within about 11 months or so, she had been convicted. And now she's still serving her term in prison. And she was touted as the Queen of Galamsey and all that and all. So really, I think that is such a big fight that we can point to. Yes, you talk about the failure to deal with other perceived perpetrators of Galamsey. But the point must be made again that clearly prosecutions are taken on the basis of credible dockets built after painstaking investigations. I have not really been made aware of the burden of any prosecutable docket in respect of any person involved in Galamsey that the Office of Attorney General has failed to investigate. There has not been any docket built after any comprehensive investigations into the operations of account mining that you say. But of course, time is not a bar. There is no time bar to the prosecution of crime, and we'll still proceed to do that. If indeed I come by any credible evidence at all, you can be assured I'll be the one, to first rush to court, because indeed I would like to also have the fame of having prosecuted another big person, just like I did for Aisha One. So really, and then again I think if you prosecute more perpetrators of the act, whether they are small or big, for me that should be a lot of deterrence. If indeed some big men sitting somewhere are pushing people into Galamsey and all that, and those people are arrested all their time and prosecuted and convicted and sentenced to minimum of 15 years in the case of a Ghanaian, minimum of 20 years in the case of a non-Ghanaian, I don't think there will be anybody at all to perpetrate such an offense. So it boils down to the point that whether they are big or not, is a prosecution efficiency of that prosecution as well as conviction that matters. And that is why I think, with all respect, the judiciary will have to cooperate with us by ensuring that Galamsey cases are concluded as swiftly as possible.
Now, when I hear you say what you just said about Akunta mining, I have to ask you, I mean, you're the same Attorney General who watched a TV program and, based on what you heard, rallied your office to take action against
Heritage Imperial.
Heritage Imperial.
Yes, it is.
So I know that it is completely within your ability to take action without waiting for the police to come to bring you a docket. And when it comes to Akunta mining, ask for the evidence that has been presented in the media. There is an orgy of it. Your own colleague minister at the Lands and Natural Resources Ministry at the time wrote to Akunta Mining to tell them that what they are doing in the forest was illegal. They called it illegal. Besides that, we brought evidence, images of Akunta mining equipment in the same forest reserve. We brought evidence of their mining site. I think all of this was presented.
I think the issue is quite simple. I mean, you allude to an action taken by a minister before I was appointed as Attorney General. We must, it's not a problem at all that it occurred before I was appointed as Attorney General. But the point I make is that we must desist from alluding to a single letter, perhaps written without regard to the appropriate context and all that, and without regard to investigations that have been done or conducted on the strength of such a letter. As I said, I mean, it takes a lot to prosecute. If in this country you find a situation where a person who even did not, seek the relevant constitutional approvals and undertook a transaction and not be prosecuted, and the matter was proceeded, and only for the court for appeal to say that there's no case for such a person to handle or to answer. I'm sorry. So clearly, it indicates that prosecution requires a lot, and I'm saying that I'm not really aware, with all respect, of any set of facts or any prosecutable docket that has been built on or in respect of Akwanta Mining. It's definitely not too late, as I indicated. And I do not think that it will be inappropriate for me to inquire from the CID. Indeed, they have such a docket. And I believe that you'll be informed.
Have you not? Have you not?
Oh, I have. And I have. There was this point made at the program that I had on Joy FM. And I made the necessary investigations as to whether indeed there was such a docket brought to my office about Akwanta Mining. And there was none at all. There was no docket that had been brought to my office about Akwanta Mining. Yes, the Heritage Imperial one, where I took action, was clear. There was an allegation that there had been judgment entered against the government of Ghana for $15.8 million by a company on account of that company's equipment having been burnt or destroyed by the government. I was quite alarmed that really the government of Ghana is going to suffer $15.8 million. It was a Saturday program on Joy FM. By Monday, I had gotten the necessary facts that the judgment had actually indeed occurred. Again, at the time that I was not at I quickly set out to undertake to set aside the judgment. But that was a matter that's clearly discernible. It's a matter that you can easily find out whether the judgment has been entered, and if you look at the judgment, are there grounds for setting aside the judgment based on facts that you can see. It's different from a situation where someone says, Akwanta Mining is really engaged in so, and I find out subsequently whether there has been docket to our office, and really there's no answer in the affirmative, that there's no such docket.
Does that fact alone not concern you, the fact that there is no docket, bearing in mind?
But I think that it's also not inappropriate for the journalist in question to petition my office. And I do that. I get such petitions all the time. I'll be Erastus. I'll be happy to meet Erastus over this issue for the necessary evidence to be scrutinized or examined together. And of course, I made the necessary conclusions.
Being the Attorney General who is able to take action based on what you see on TV, why must Erastus be the one to petition you?
Because you are alluding to some evidence, some tape, some production by Joy FM, which I have not seen, with all respect.
So the question is, why must it be Erastus petitioning you? Why don't you take the phone?
But I said to you,
ask him to bring you the evidence he has.
I do not, so should I say I should call Erastus right now?
Why not?
I do not even have Erastus' number, with all respect. If you give Erastus' number today or so,
you're the Attorney General. That can certainly not stop you.
But you see, I think there must be a modicum of fairness to me. In the middle of an interview, you inquire about certain matters that a colleague of yours has raised in a production.
Years ago, by the way.
I'm not even aware of whether it was years ago. I thought it was even this year. You are saying it was years ago. I've not seen such evidence. And now you are saying, why haven't I called the person so far? I mean, clearly that's a little bit unreasonable. And I'm saying that it is not inappropriate for the person, if indeed the person is truly concerned about environmental matters and prosecution of environmental crime, to petition the Office of Attorney General and for us to commission the CID of the Ghana Police Service to undertake the investigations, and they will do that. And I said to you that early on, there was some news that I heard on one radio, I think it was Radio Joy FM, speaking about the transmission of a docket to my office about Akwanta Mining. And I found out that there was no such transmission, there was no such docket at all referred to the office.
Staying on Galamsey, Erastus recently was kidnapped, assaulted.
Really?
Yes. I'm assuming from your response that you are not aware of this.
Definitely not.
Okay, well, this has certainly dominated the media space. Erastus has reported that he and 3 other colleagues from Joy News investigating reports of illegal mining leveled against a particular mining company were picked up by over 10 armed men, taken to an undisclosed, unidentified location, beaten, their equipment destroyed and some of it seized. They made a report to the police. The police returned to that site armed, met the men there, but for some reason were unable to arrest them. 3 of those men then voluntarily reported themselves to the police. They were immediately given police inquiry bail.
Wow.
Since then, there is no knowledge of a case in court. Is your office aware of any? Well,
I'm not aware.
Since you don't even know that this event
yes,
occurred.
but that's very unfortunate. I mean, that clearly would be torture, in my view, if indeed a citizen of the country is just taken up from somewhere to an undisclosed location and for such treatment to visit another person. That would constitute torture. I'm surprised that such a thing will happen. I'm aware that the Ghana Police Service has very much improved on its standard operating procedures, and I do not think that in the scheme of operations for the Ghana Police Service now, there will be such room for infliction of such torture. It's something that is news to me. I've not heard about it at all. And again, I would say that the same response I give, I think such a petition ought to be made to the Attorney General and for us to commission the relevant institutions to investigate. But of course, the denial or grant of bail, in such situations is something that I actually frown upon. I have actually, again, bemoaned the tendency of the court to grant bail to people engaged in galamsey offenses. And it's one of the reasons why the fight against galamsey is not really going far at all. The mere fact that every offense in Ghana is prosecutable does not divest the court of the discretion in refusing bail. The court is still seized with the power to either grant or deny bail. And that's a discretion the boast of the judge and is exercised according to the specific circumstances of the matter. So I have always complained about judges being lenient when it comes to consideration of bail for galamsey offenses, because usually you grant to them and then they go back and I would say that such a situation, I'm surprised that there will be such police inquiry bail. I do not know the circumstances, but I'm not in the position to make any judgment at all about the conduct of the alleged police officer and that kind of thing.
Parliament has certainly given us a lot to think about in terms of the constitutional issues raised in Article 97 G and H, following the declaration by the Speaker a few weeks ago that 4 seats are now vacant as a result of the filing by the holders of those 4 seats to run for Parliament on different platforms than the ones they came in on. This matter has now made its way to the Supreme Court, where some rulings have been made. You yourself were a respondent in the claims made by the majority leader, Afenyo Markin. Now, this is an interesting situation. I'd love to, first of all, hear your take on it, bearing in mind the fact that you seem to, at least by your submissions in the Supreme Court, you seem to agree with the party that is making you a defendant.
Well, so first and foremost, the point has been made that in a constitutional issue or a constitutional case, there isn't so much of a cause against a specific person. So there's no interest necessarily that a particular person in Ghana will have personally in a constitutional question. The question is for the court to determine the constitutionality of an action, a decision, or of a law. If Parliament passes a law and that is being questioned, it is not the interest of the members of Parliament at stake. Members of Parliament do not have a specific or direct or personal interest in a law at all. So the point has been made way back in 1980 with the famous case of Tufo Attorney General and other matters, and that was 44 years ago, that in a constitutional case, the community of interest or the community of interest of the parties is with the Constitution, not personally. So when the Attorney General is sued in a constitutional matter, it is not because the Attorney General has done X, Y, Z that the Attorney General has been taken to court. It is not because the President's personal matter is being dealt with by the Supreme Court at all. Because indeed, as I said, the Constitution is supposed to govern everybody, especially the principle, the basic law of the country. And that is why the Constitution itself recognizes the seriousness of the instrument that it sets out for the people, and then determines a specific institution to interpret that Constitution. and the interpretation of that constitution is binding on all. Again, it's also because a person has no direct or personal interest in a constitutional question. That is why the constitution makes the Attorney General the defendant in all government actions. Right. We all work on behalf of the government, but the government is not our personal property. The state is not our personal property. If I take a decision as a public officer, I take so by dint of the law that is imposed on me. And I walk away from this office, the next Attorney General will be saddled with responsibility for the action that we take. It tells you that we have no personal direct interest in it. So for that reason, I think philosophically, even Parliament is not supposed to be a party in constitutional actions.
So you think it was wrong for Parliament to have been made a party?
In my view, it's wrong.
matter?
And I raised that point. The Supreme Court did not rule on it. But again, some other lawyer would have gone outside court and be making noise, writing articles in the media or the internet that the Supreme Court refused to rule on the questions. There's nothing at all. There's nothing personal. I raise my questions. If the court decides to rule, so be it. The courts do not rule unless it's very important to the exercise in question. I will not even pursue it. So the number of points I raised that day in court, that was one of them. That I do not think Parliament is even a proper party. The court did not rule. I also raised the issue that for me, the Council for the Speaker of Parliament cannot even be holding proceedings, holding our proceedings or holding everybody to ransom on account of failure to file processes, because indeed he is not even mandated, lawfully mandated by the laws of Ghana to represent the Speaker, because under the laws of Ghana, a public officer, when he is acting and seeks the services of any other person or institution, seeks the services of a person, will have to act so in accordance with the provisions of the Public Procurement Act, and that has not been done. The court did not rule again on that issue. I left it at that. I also raised the issue that even the Speaker's motion fundamentally was flawed, because it ought not to have been brought at all, because when the Supreme Court makes a decision and there's supposed to be a challenge to that decision, it must be in accordance with Article 183 of the Constitution. Article 183 of the Constitution requires that any decision or action, any decision, simple, any decision of the Supreme Court is subject to review. And the review must be conducted in accordance with Article 183, which is, it must be by a court of a minimum 7. The Speaker filed a motion not for a review, but to set aside the decision of the Supreme Court. That is even flawed fundamentally. It's unknown to the Constitution. The court did not rule on it. The court decided to look at it in merit and then dismiss it. That is fine. I don't have an issue with it. So I again will reiterate that yes, if I make any argument in the Supreme Court, just to answer your question again, if I make any argument in the Supreme Court siding with a case or opposing it, it is not because of a personal interest I have, but it is on account of a faithful view I take of the provisions of the Constitution. And it's quite clear, the Constitution is supreme, the sovereignty of the people is upheld by the Constitution, we are all subject to the Constitution. Parliament of Ghana can never be supreme, and indeed that supremacy of Parliament is definitely offensive to the Constitution and cannot be detained in the interest of a preservation of the constitutional order of the country.
The Speaker has had a press conference just today, and he's raised a number of issues. One of them is that he claims that the President and the Supreme Court have sinned against the Constitution. What's your take on that?
I think the first and foremost, we must recognize the irregularity or perhaps unusualness of the decision of the Speaker to make a press conference. In my short life, I've not seen a Speaker of Parliament address the nation on a decision of the court. That is because the Parliament itself recognizes the compartmentalization of rules set up by the Constitution. The Constitution has compartmentalized functions. The executive has its own functions to maintain law and order and to ensure that the needs of the people are satisfied in law. So indeed, it cannot be questioned how the executive decides to prioritize one project over another, unless it is in violation of the law. So certain things, perhaps, I think we must agree on it. Certain things have to be agreed, otherwise there cannot be a preservation of this democratic order of the nation. And that's my prime concern, that the road on which we're traveling, if care is not taken, there will be disintegration of the democracy that we have chosen for ourselves. And there will be recourse to self-help, which ought not to be the case at all. I, with all respect, saw the Speaker as trying a little bit too much. He's my very good friend, and for that matter, I mean, I'll just say so. Trying too much because, as I said, I did not see how conventional it is for a Speaker to address the nation after a Supreme Court ruling and express his views on it. There's freedom of speech, no doubt. Every person has the right to express his freedom of speech on a decision of the court. President Joe Biden recently expressed his view on the Supreme Court judgment over long Supreme Court decision, Roe and Wade, overturning the position of the court on abortion and what have you. Of course, we also know what's happening to the Democratic Party now. Perhaps even the defeat was occasioned by such positions and all that it took after the Supreme Court had expressed a rejection of the position of the court taken in Roe and Wade, and of course, which of course leaned towards more of a conservative approach when it comes to abortion and all. So I think that it must be recognized in this country that we're all subject to the Constitution. And when this is done, we will require a certain level of humility, certain level of reasonableness, and a certain level of respect generally for other institutions.
You feel that the Speaker is not exhibiting humility, reasonableness, and respect for institutions?
I'm not. You see, from as usual, right? I'm sorry.
I have to ask because you made the comment.
I'm saying, because indeed, I mean, as I told you, I feel very convinced about certain matters I take to court. The recent case of forcing, the Republic versus case of forcing, I think that the matter clearly should be prosecuted and is prosecutable. All the elements of offenses had been proven. The trial was advancing. I was actually sitting in my study preparing to go and continue the trial when I received a phone call that the court of appeal had set aside the judgment of the ruling of the High Court on the submission of no case earlier on, made over a year before. Clearly, I was aggrieved, but I